You, Amanda Erent? And will your client waive the formal reading of the motion?
She will, Judge.
Give me just a second. All right, so this is 15-23083, and it's on probation. July 31st of 2017 for the offense of intoxication manslaughter. At the time, that was a 10-year deferred probation, and we have spoken off the record, Mr. Parker and Ms. Malfino and I, realizing that that was obviously an error that took place. And Ms. Erent, I know Mr. Parker has gone over that with you as well. Is that correct? And so with everyone's permission, it's my understanding that everyone agrees that I go back and modify that judgment from 2017 from a deferred probation to a conviction with a straight probation. Is that correct?
Yes, and I believe, Judge, we agreed to it being 10/10.
Would make sense. And Ms. Erent, you've gone over that with Mr. Parker and you agree. Is that correct?
Yes, I've explained to you about the error in the judgment and what we're doing here today, and we're amending that judgment to reflect what it should have been there. And
a clerical error from 2017 has come back to life, and it may destroy Amanda Erent's future. Every violation she admits pushes her one step closer to prison. But when the judge finally reveals the truth behind this correction, everything changes.
It's going to be retroactively, so it would be like it happened at that time. You were sentenced to 10 years prison, but you got 10 years probation.
So then at this time, based on the previous plea and all of the information and admonishments that were given back on that plea date, I am going to retroactively, with everyone's agreement, find Ms. Erent guilty of intoxication manslaughter, assess that punishment retroactively at 10 years in prison, probate it for 10 years, which gets us here. All of the other conditions, fines, and everything would remain the same. So the judgment from back then will just need to be knocked to show that it was a straight probation with that conviction instead of the deferred probation. Now, with that being said, will she waive the formal reading of the motion?
She will, Judge.
And at this time also, Ms. Malfino, I think it probably, to make it clean, I think the state could orally amend that motion. Let me print it out so I can make that in writing on here.
Here you go.
I'll get one. It's all right. Thank you, though. Go ahead, Ms. Malfino.
And Judge, I would make an oral motion.
Amanda quietly pleads true to every failure, missed reports, unpaid fees, a life spiraling out of control. The courtroom falls silent as the judge says the words, "I revoke your probation." But the deadliest blow is still coming, and it involves the car that killed.
For the court to amend the motion to revoke to reflect the period of 10 years probated for 10 years from back on the sentence dated July 31st, 2017.
There's no objection.
All right, so I will make, with also in the title, with everyone's permission, I'm going to make the modification that just says motion to revoke probation and take out unadjudicated. Is that agreeable? All right. Okay, so now let's go through the motion. Ms. Erent, in 15-23083, I have a motion to revoke your probation. Shows that you were placed on probation July 31st, 2017 of intoxication manslaughter. Shows now that that was a 10-year sentence in prison that was probated for 10 years. And it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department in Harris County, June 9th of 2021. Is that true or not true?
It's true.
Count 2 alleges that you failed to report to Jefferson County by mail March, May, and June of 2021. Is that true or not true?
It's true.
Count 3 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true? Count 4 alleges that you failed to immediately report to the probation officer your change of address. Is that true or not true?
It's true.
Count 5 alleges that you failed to immediately report to your probation officer your change of employment. Is that true or not true?
It's true.
And then count 6 alleges that you are behind in your court-assessed fees.
That's true.
Did you enter your pleas of true to counts 1 through 6 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection?
It's admitted. Any evidence that Ms. Erent's not competent?
No, Your Honor.
Right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement for a term of 8 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. The state is asking that I make an affirmative finding of a deadly weapon. State's exhibit number 2 that's been admitted is the probable cause affidavit that shows underlying offense. Mr. Parker, any objection or comments with regard to that?
Obviously, she'd rather it not be found. I understand the court position, so we defer to the court.
All right, I am going to find that there is affirmative finding of a deadly weapon, the vehicle in this case, and sentence you again to that term. I am going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I will also hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
Amanda Erent stands before the court, a woman haunted by a single night that cost a life and reshaped her own forever. What once looked like salvation, a deferred 10-year probation, is now exposed as a recording error that never should have existed. The judge moves to correct the past, transforming her deferred status into a conviction, instantly removing the only legal shield she ever had left. Amanda nods, quiet but trembling, agreeing to the retroactive change that rewrites the last 8 years of her life. Then comes the reckoning. One by one, the judge reads out Amanda's violations: missed check-ins, lost employment, change of address left unreported, and fees she could not keep up with. Each one earns a soft, heartbreaking true from Amanda, her voice shrinking as hope drains from the courtroom. The judge acknowledges the plea agreement and delivers the inevitable: probation revoked, 8 years in state prison. But justice has one more blow. The state pushes for a deadly weapon finding, and the judge grants it. The vehicle Amanda once drove becomes, legally, the weapon that took a life. With that finding, the law will not allow early release. Prison becomes not just punishment, but a prolonged reminder. As Amanda is handed her appeal waiver and firearm restrictions, the scene shifts. Another defendant, Miss Allen, learns that violence and disrespect in jail leaves no mercy here. The judge warns that prison will be harsher still. 2 women. 2 lost chances. 1 courtroom where consequences arrive without emotion, only finality. In the end, this is a story about one decision, one moment of recklessness, and how its aftershocks never stop echoing.